All right, welcome everyone to our webinar that will highlight strategies to navigate human resources and legal impacts to businesses during the pandemic. My name is Gabriel Sester. I am the Small Business Recovery Navigator with the Brattleboro Development Credit Corporation. This webinar is a continuation of the Restart Vermont Technical Assistance Program. If you are a business who has already received support through the REVTA program or happen to be a vendor who provided technical assistance support, thank you for taking advantage of the opportunity. And for those of you who did not get an opportunity to receive support through the program, thank you for joining this webinar, and hopefully it will contribute well to your operations. Today, we're grateful to our panel featuring Maribeth Spellman and Karen Tierney from the HR benefits firm Hickok Boardman, and Timothy Copeland and David Harlow from the legal firm Downs Rachlin Martin. In a little bit, we will start off with a presentation from DRM. The presentation will be followed by a panel discussion moderated by the Pdcc's Executive Director, Adam Grinold. And throughout the meeting, two other Pdcc employees will be monitoring the chat for questions. You can post as the meeting is going on, and we will curate questions to add on to the end of the meeting after the panel discussion. Please, just as a ground rule, keep your microphones muted throughout the meeting. This will be recorded, so if you have other businesses who you would like to share this with, and if you would like to watch it again in the future, that will be available to you on the Vermont Economic Development website afterwards. And thank you all for joining. We appreciate your attendance. And now I will be handing it over to David Harlow and Tim Copeland from DRM.
Hello, good afternoon, everybody. My name is David Harlow. I'm a lawyer with Downs Rachlin Martin. I'm based in the Brattleboro office, together here with my partner and colleague, Tim Copeland. We practice in the Labor and Employment Practice Group at DRM. And what we do on a daily basis is advise employers of all shapes and sizes throughout Vermont and elsewhere on legal changes that affect the workplace in disputes and dealings with employees and with labor unions. The principal goal of this presentation is to provide you with a timely legal update on some emerging matters that relate to COVID-19. And those come in two principal areas. One, in terms of the vaccine and how employers should handle and respond to that. And two, how to handle and respond to employee requests for leave or time off related to COVID-19. And with that, I'm going to share a PowerPoint here with the group. I am going to operate under the assumption that everyone can see that. If that's not the case, please speak up. Just as a preliminary matter, and we do this for every presentation nowadays almost, but we include a note disclaiming some of the content of this information in the sense that it is not legal advice. This is general information that applies broadly to employers, but it's not individual legal advice because almost every legal issue depends on the facts and the circumstances of the particular employer and employee. And so each of you will have different ways to apply some of the legal rules we'll be talking about, but these rules vary quite a bit depending on context. They also change very rapidly and overnight, in fact. And in fact, last night, we had the passage of a stimulus bill that, as Tim Copeland will describe, included some changes as regarding the paid leave portions of the Families First Coronavirus Response Act, which some of you may know as paid COVID leave. That law was set to expire on December 31st, and literally last night there were some changes in as far as how that law is going to expire. You may have also recently seen some headlines. There was one in the New York Times on December 18th that just said employers can require workers to get COVID-19 vaccine, US says. And this is a catchy headline, and it certainly caught my attention. But I'm here to warn you that it's not particularly good legal advice. The basis for this article and these stories is a result of EEOC, quote, guidance that was issued on December 16th, 2020. I want to warn you that guidance is exactly that. It is guidance. It is not the rule of law. And the EEOC, although it can be very influential in how federal employment and labor laws are interpreted and enforced, is not a court of law, is not the legislature, and doesn't have the ability to promulgate new laws in the traditional sense. So although this guidance can be helpful for employers in interpreting situations and how legal issues may unfold at some point, I want to be very clear with everyone that the guidance that was issued and that prompted this headline really is guidance. Now, one of the key issues that's raised by this headline and the EEOC guidance is what can employers do now that we have a vaccine rolling out to ensure that its workforce is safe and to the extent possible vaccinated from COVID-19. And I want to stress a few key sticking points to anyone who wants to implement a mandatory vaccination policy in their workplace. Number one, if you were to enact a mandatory vaccination policy that would require all employees to become vaccinated as soon as possible, you would have to make sure that that policy contains exceptions and procedures for employees who raise disability-related concerns as it relates to the vaccine. The vaccine requirement in any employer policy itself would need to be job-related and consistent with business necessity. If an employer who has employees working solely from home and who always work solely from home and pose no threat of infection of others at the workplace, it would be very hard to demonstrate that that employer has a job-related and business necessity requirement that would prompt a mandatory vaccine. So any employer who wants to implement a mandatory vaccination policy should be thinking about, is this really necessary for the safety and health of my workforce? If you determine that it is, and you in fact include a mandatory vaccination policy, and you as the employer decide that you're going to apply or administer the vaccine yourself, and this would happen most frequently in the healthcare context, one needs to be very careful about asking questions that might reveal information about a disability when administering the vaccine. Sometimes employers outside the healthcare context will also contract with third-party vendors to supply a vaccine, and this typically happens historically in the flu shot context. If that third party has been contracted by the employer to administer the vaccine, these same rules apply. You need to be very careful about asking questions that would reveal information about a disability. And what happens if a question is asked in the pre-screening process for the COVID-19 vaccine that does reveal an employee has some unknown or previously undisclosed disability? Well, that triggers a couple options for the employer. Number one, you've got to maintain confidentiality of that disability-related information. Number two, if the employee is saying, I have an underlying health condition that disqualifies me from being able to safely receive the vaccine, the employer is then placed in the position of conducting a reasonable accommodation analysis. And the way this would work is something like as follows. If an employee raises a disability-related issue that prevents them from getting a vaccine, the employer needs to make a decision. Okay, is giving this employee the vaccine a matter of a direct threat to the health and safety of my employees, or is it just something I want them to do? And if your answer is it's just something we want them to do, you should not require them to get the vaccine. And you should allow them to continue to be employed in their current capacity. If you determine that there is a potential threat to health and safety of the employee or others in your workforce, perhaps because they work in a restaurant and they're a server and they come into close contact with customers and with other people, then you have to say, all right, there is a threat to health and safety here. Is there some way I can provide an accommodation that would reduce or eliminate that risk to a reasonable level? And in some cases, there might be situations where you could do that. That might include, for some employers, allowing remote work, allowing employees to wear face masks, or taking a temporary leave of absence in some cases to recover from whatever disability prevents them from getting the vaccine. And I'm overgeneralizing here, but the point is, it's not as simple as the New York Times made it sound. It's not a matter of simply mandating a vaccine and then looking the other way when employees say they're not able to do it. Another sticking point is religious accommodations. And there's a similar, although less arduous process an employer would need to follow for employees who raise religious-related concerns with getting a vaccine. Under Title VII of the Civil Rights Act of 1964, employees do have the ability to request religious accommodations. Some common examples would be wearing a headscarf at work, in derivation or in some way that would go against an employer's dress code, having days off that are observed, that are used for religious worship and observance. Those types of issues usually come up, but they can also come up in the context of a vaccine. And I don't know specifically how they might arise here, but there are certain religious beliefs that prevent vaccinations and may come up in the course of requiring employees to get a COVID vaccine. If that happens, the employer has some obligations. Number one, if you have a basis to believe that the request is not objectively reasonable, in other words, if you suspect that this person's religious beliefs are really something that they made up and not something that's sincere, you do have the ability to inquire and provide some substantiation for the request. Otherwise, the employer, assuming the belief is sincerely held, has the ability to conduct an accommodation analysis that's similar to disability, although the threshold for showing that the request would be unreasonable or an undue hardship for the employer is a lot lower. But the key point here is to be cognizant of the fact that there are protections for religious-related accommodations. And again, it's not quite as simple as simply mandating the vaccine and looking the other way. So outside of mandatory vaccines, what are some other possibilities here? One possibility here, and one that avoids a lot of legal problems, is to implement a voluntary vaccination policy. And this would almost in every case eliminate a lot of the religious or disability accommodation issues. If you do elect to do a voluntary vaccine policy, employers need to remember that this, if it's voluntary, it has to be truly voluntary. And if the employer administers pre-screening or disability-related questions in the course of administering the vaccine, those answers need to come voluntarily as well. And relatedly and significantly, if an employee decides not to get the vaccine, they can't be retaliated against based on that decision. So voluntary vaccines are vaccine policies for employers have some definite advantages in terms of avoiding legal hurdles, but they also have the downside of not being quite as compelling for employees to get the vaccine. I'm hopeful, and I think a lot of people are hopeful, that because of how bad COVID-19 is. Employers are going to be motivated out of self-interest. But to the extent your organization can do this, it also can be helpful to motivate employees by getting company leadership involved, having the president of the company, somebody of that stature, receive the vaccine and promote it. And if possible, to make arrangements for offering the vaccine at the place of employment down the line, of course, when that's possible, and promoting the vaccine that way, similar to the way that a lot of employers promote flu shots today. So I want to conclude here just by listing a few other things that employers should be thinking about as it relates to vaccines. Number one, employees do have the right to get together and complain about decisions that employers make for their mutual aid and protection as it relates to their terms and conditions of employment. And some of that legal language I'm speaking comes from the National Labor Relations Act. This means that if employees were to band together and say, we disagree, employer, with the position you're taking on mandatory vaccines, we don't think it's safe, we think it's going to be more harmful than helpful, what those employees would be doing is engaging in an activity protected by federal labor law. So be cognizant of that. Number two, also related to the NLRA, an employer that is too heavy-handed or too insensitive in the way that it administers its policies could find itself on the receiving end of a union organizing drive. And so as you roll out policies related to vaccines and basically any policy that you roll out relating to your employment or your employees, keep in mind that employees do have the option in many cases to get together and form a union. Also relatedly, if you do already have a union and you want to implement a mandatory vaccination policy, that's a mandatory subject of bargaining too. And so you'd need to get input and consent from the union to be able to pursue that. There's also whistleblowers, and OSHA protects people who complain about threats of safety in the workforce. And I'm not exactly sure yet how that will come up, but I think it might in workforces where the vaccine's available, after the vaccine's available, where either employees make safety complaints, either because other coworkers or members of the public are not vaccinated, or because they're concerned about the safety of the vaccine themselves. Recognize that those types of safety complaints are very often protected under the law, and an employee can't be retaliated against for making them. There's also the possibility of some workers' comp issues coming up that are heretofore unaddressed in the law. For example, an employee who gets a vaccine pursuant to a mandatory requirement and then suffers ill side effects, is that a compensable claim under Vermont law? We shall see. And then finally, and this is a nice segue to Tim's presentation, there's going to be some changes to state and federal law on these issues as we go forward. So it's important to keep abreast of these developments and attend sessions like this, and continue to monitor these changes as they develop. We've reached out to the state attorney general. Tim sent an email to the chief of the civil rights unit to find out how the state is interpreting and implementing this vaccination related guidance. As far as I know, we haven't received a response yet, but my point is that there is going to be some further guidance we expect under state law as well as federal law as it relates to these issues. With that, I'm going to turn it over to my colleague, Tim Copeland, who's going to talk about some of the COVID-19 leave-related requests.
Okay, thank you, David. Good afternoon, everybody. Nice to be with you all today, and I see a few familiar names and faces from around the state. Let me just start by annotating something that David talked to, and that is the subject of guidance from the state, and it relates to the EEOC guidance that he mentioned, which is obviously helpful as far as it goes, but it's important to keep in mind that that EEOC guidance is with respect to its interpretation of the laws that it in two of the statutes that it enforces, the Americans with Disabilities Act and the Rehabilitation Act, which are federal statutes. But for us Vermont employers, there is a state statute, the Fair Employment Practices Act, that contains its own set of limitations and restrictions on disability-related inquiries and anti-discrimination provisions. So we really need to know that the Vermont statute is going to be similarly interpreted in order to have a clear answer on the subject of mandatory vaccinations. And as David said, we are in the process of trying to get some guidance from the Civil Rights Unit of the Vermont Attorney General's Office, which is the state agency that enforces that statute on behalf of some of our clients. So let's turn now to some COVID-specific laws that were enacted. This takes us back to March of this year, just as the gravity of this emergency was descending on us. Congress very quickly passed the Families First Coronavirus Response Act, which for the first time, at least with respect to private sector employees, created federally required forms of paid leave, a couple of them. The first one was referred to as emergency paid sick leave, which required employers of under 500 employees to provide up to 80 hours, in other words, 2 weeks of paid sick leave at the employee's regular rate of pay because the employee would be unable to work due to a quarantine order by a government or healthcare provider, or was experiencing COVID symptoms and was in the process of seeking a diagnosis. Didn't require that the employee had already obtained a positive diagnosis. This requirement kicked in immediately, meaning that it was available to even an employee that had started with the employer the day before. Except for that 500 employee limitation, there were no exceptions to this requirement for small businesses. The idea behind this obviously was to make it to cushion the financial blow when employees couldn't or shouldn't be at work due to the virus. Obviously, it was not intended to be available to employees who could telework, who could do their jobs remotely. And the Department of Labor was rather dogged in its regulatory guidance that this leave is not available to people who did not have work available to them at the time the employee needed to be away. So if the employer had conducted a layoff or a furlough, or even just temporarily or permanently closed its doors, the DOL took the position that you're not eligible for leave if there wasn't work for you to leave. And they took that even though there was some federal litigation that struck that part of their regulation. Now, back in March, when Congress quickly enacted the statute, of course, everybody thought and hoped that this emergency would be well behind us by the end of the year, and the legislation was designated as temporary and by its terms would expire on December 31st, which is 9 days from now. In a minute, I will get to what has happened just in the last few days that doesn't entirely extend the requirement, but there's a caveat to that. Let's go to the next slide. Okay. Emergency family medical leave was the second form of, if you will, paid leave created by the FFCRA. It amended the Family and Medical Leave Act to provide for up to 80 hours of paid sick leave at 2/3 of the employee's regular rate of pay if the employee was unable to work due to needing to care for an individual subject to a quarantine order, or to care for a child under 18 where the school or child care provider is closed or unavailable for reasons related to COVID-19, or for substantially similar conditions related to COVID-19. And finally, the law created an additional up to 10 weeks of paid expanded family and medical leave at 2/3 the rate of pay where the employee is unable to work due to school or daycare closures. There were some limited exceptions here where providing leave would, quote, jeopardize the viability of the business as a going concern, and a requirement that that these forms were available only to employees who had worked at the employer for at least 30 days. And like the emergency paid sick leave, this one was designated to expire on December 31st. Now, both of these forms of leave, although they created requirements for employers to provide paid leave, those employers qualify for full reimbursement through tax credits for the sick leave and the emergency family medical leave. So in effect, it was the federal government that was the funding source for these forms of paid leave. So what is going to happen on January 1st? Well, Congress has passed, as part of a Consolidated Appropriations Act for 2021, a new COVID-19 emergency relief package. It does not extend the emergency paid sick leave or the family leave laws that I just mentioned. So in the first instance, the mandate, the requirements to provide those forms of leave are going to expire on December 31st. But what the legislation does do is provide that between January 1st and March 31st of 2021, covered employers can voluntarily provide or continue to provide those forms of leave and take the corresponding tax credits. It doesn't require, it appears not to require an employer to do that. I should, I guess, emphasize here that we're still digesting this legislation, which was over almost 5,600 pages. As we interpret the language, it wouldn't give a new bucket of leave. So if you have an employee who took 80 hours of emergency paid sick leave in 2020, it would not be wise to assume that that person gets a new 80 hours of emergency paid sick leave to use sometime in the first quarter of 2021. Certainly the employer can give the person the paid sick leave if the employer wants to, but it does not appear that that provision, that second bucket in that situation would the employer could get a tax credit for that. But setting that aside, if you have employees that have never taken COVID leave, but then find themselves needing it sometime in January, February, or March, employers can, if they choose, provide the paid sick leave, the emergency paid sick leave, and take the tax credit for it. Now, that's obviously sort of a stopgap measure. And there are certainly lots of government programs that are on the books for decades after they were initially passed, intending to be temporary. So watch out for something further to be done. We know that President-elect Biden has described what has just passed Congress as only the beginning. We consider it quite possible and maybe even likely that President Biden will favor some further extension and maybe even make paid sick leave and paid family leave permanent parts of the federal statutory makeup. But we'll have to stay tuned for that. In the meantime, what should you as employers be considering? Well, if somebody comes to you on January 2nd and says that they are ill or they have symptoms and they're in the process of seeking a diagnosis for COVID, of course, keep in mind that the traditional Family Medical Leave Act and Vermont Parental and Family Leave Act rules will still apply to that person. So that means at a minimum 12 weeks of unpaid leave, the right to be absent from work and be reinstated at the end of that absence. And if the person still has some portion of the full 12 weeks of annual leave remaining, then those would certainly apply to a COVID diagnosis, which is, of course, a serious health condition. Vermont has had for about 5 or 6 years now a paid sick leave statute that requires employers to adopt a paid sick leave policy, allowing employees to accrue 40 hours of paid sick leave per year. And of course, that would apply to an employee who becomes sick with COVID. It also has applied to an employee that needs to be away from work to care for a family member because the school or business where that individual is normally located is closed. And that has been the case for snow days in Vermont ever since the statute passed. And needless to say, it would kick in if a child can't be at school because the school is closed because of a public health reason as well. As I mentioned, ADA and at the state level, Vermont's Fair Employment Practices Act remain on the books and could very well apply to a COVID-related situation. Query whether having COVID-19 would be considered a disability. And there isn't really one answer that applies to all situations, but based on the way that the word disability is defined in those laws, it could be if the disease changes the way an employee's body functions such that it substantially limits the employee in engaging in one or more major life activities, which now are understood to include working. This is an area of the law that's, of course, it's so new that it has not been subject to, testing all the way up to the Supreme Court, but it's something that we're keeping an eye on. And finally, as we look to the end of this year and the apparent expiration of the two laws that were passed quickly in March of this year, keep in mind these are not banked forms of leave that employees get to cash out if they don't use them by December 31st. They are what we refer to as use it or lose it. That second bullet, of course, needs to be amended now that the Congress has acted. No tax credits after March 31st, 2021 is the new state of things there. The anti-retaliation provisions of the bills will continue to protect employees, so no employer should take adverse employment action against an employee because the employee requested emergency paid sick leave or family leave. And of course, as employers consider the question, now that I don't have to provide these forms of leave, should I anyway? Employers will want to keep in mind, well, do we really want to put an employee in the situation where they feel like they're going to have to come to work because they need to make money, even though they might be sick? These are ultimately, of course, business judgments here, but at least for the time being with this 3-month cushion, an employer that's leaning towards providing those forms of paid sick leave can do so knowing that that they can take the tax credit against it. And I suspect that before we get to the end of March of this year, the new administration at a minimum, and perhaps even Congress, will have acted to set the stage for more longer term forms of leave. Thank you.
All right, thank you, gentlemen. I will now be handing things over to Adam Grinold, who, as I said earlier, is Pdcc's Executive Director. Just for a little bit of context for people who may be unfamiliar with the Pdcc or any of the regional development corporations, the Pdcc was the statewide lead for the REVTA program, coordinating almost 100% of that activity, as well as supporting the Windham region. And Adam will be moderating our panel discussion with our 4 guests today. So Adam, thank you for being here and take it away.
Great. Thank you, Gabriel. So it's great to see a lot of the names familiar through the REVTA program. So for those of us joining who are participants in REVTA, I'm glad to have you here and glad to have had your participation in the program to date. So we have a series of questions for our panelists. So we've got several of them. The goal is to get through a list here. And as Gabriel mentioned earlier at the beginning of the session, we've got 2 of our team members who are reviewing the chat questions, and we'll sort of collect those into some buckets so that we can be sure to address those questions as well. So feel free to post questions here. If they get addressed during the panel, we'll skip over those. and address the rest following the panel discussion. So to start off, our first question is, can we require an employee to notify the company if they have been exposed, have symptoms, or have tested positive for COVID-19 coronavirus?
Thanks, Adam. So I'll get started, but first I'd like to just say hello, everyone. I'm Karen Tierney. I'm an HR consultant for Hickok Boardman HR Intelligence, and we work with employers of all shapes and sizes to help them with developing and implementing HR programs to help them attract, engage, and retain the best talent. And so glad to be with you today to start by answering the questions. Obviously, the rest of the panelists should please feel free to join in. Can we require an employee to notify the company if they've been exposed, have symptoms, or have tested positive for the COVID-19 coronavirus? So yes, not only can you, but you should require any employee who becomes ill with coronavirus symptoms while they're at work to notify their supervisor or human resources. And employees with symptoms should be sent home and should be directed to remain at home until they're symptom-free for at least 24 hours. However, if an employee becomes ill with coronavirus-related symptoms while they're outside of work, or they've been exposed to someone that is exhibiting symptoms or has tested positive, the employee should call in or contact work and should not report in.
Great. Okay, so next question, for those employers out there fortunate enough to be able to hire folks during this pandemic, you know that can be a challenge in how to actually navigate that process. So what steps can we take to protect the workforce during that process?
Yeah, hi, I'm going to take that one. Nice to meet you all. My name is Maribeth Spellman. I work with Karen Tierney at Hickok Boardman. I also like to just let folks know, I consider myself a recovering lawyer. I actually practiced labor and employment law for the federal government and with the state for about 15 years. And I now focus on business development and HR consulting work. And relative to this question, to Adam's point, we do have clients and we do have businesses who are in the fortunate position of actually hiring people. I actually have a sister who is a FedEx truck driver, and needless to say, FedEx is hiring left and right. And to answer this question, there is EEOC guidance relative to this that says, yes, you can do screening and symptom checking type of screening upon issuance of a conditional job offer, right? And then you can also, if you want to, if somebody presents and you've made them a job offer and they, they are showing symptoms or they kind of self-report some symptoms, you can sort of delay their start date because of those symptoms. And I know a lot of employers, are doing daily symptom checks as well. That is a good practice, depending on the type of work environment that you have. But to David and Tim's point, also the EEOC guidance is simply that, it is guidance. It is a good resource for employers. If you haven't checked out their website and looked at kind of their pandemic resource center, I would suggest that you do so. It's always a good starting point to kind of get your bearings. And then if the situation is complex, as with individual circumstances and humans, it often is. Those are the times when you call folks like Tim and David to get more into the details of your situation. So thank you.
Great, thanks very much. So for many employers, they require their employees to travel out of state to conduct their work. So this question is, how do we manage that? Do we have to pay them for that time? And then do they have to be quarantined when they're there in the new state as well as when they return home?
Thanks, Adam. I'll try to tackle this one. And the out-of-state travel issue can be very tricky. There's been a number of different variations of it. Sometimes people travel on vacation to Florida or to other states and then come back. And the question is, well, now do they get to stay home with pay for a couple of weeks after they just took vacation? Another variation, as you described, is an employer who has a need for an employee to travel across state lines, and whether that triggers a quarantine obligation. The way to look at this is twofold. One, is there a government order that requires a quarantine? And number two, is there a law that requires for paid time off to undergo that quarantine period? In the vacation example, there most likely would be a quarantine period required by our state's current executive order upon return to the state. But the question of whether or not that time needs to be paid under the federal paid leave provisions that Tim described is going to change on December 31st when the requirement to implement those policies will lapse. Up until December 31st, if you have an employee who goes on vacation to a distant state with your consent and approval and returns, you should expect to have them quarantine and to have to pay for that time. But the key point is there, you don't have to approve all vacation requests. And so what we've been advising employers to do throughout this year and throughout the time that the FFCRA and those paid leave provisions have been in place is to require employees who are requesting time off for vacation to reveal out-of-state travel plans. And if the quarantine period and working from home for that 14 days isn't consistent with your business needs, you can deny the vacation request. Now, in the example of going across state lines to work is an essential function under the executive orders. And so it's possible that an employee who travels back and forth across state lines on a daily basis, for example, lives in New Hampshire, works in Vermont, there would be no quarantine requirement, and therefore, of course, no paid leave requirement. For an employee who travels on a business trip out of state, I think the employer should recognize that that's going to trigger a quarantine requirement. And presumably, if that's an employee who can travel out of state, a lot of times the employer can arrange for that person to work remotely upon return to the state during the quarantine period, in which case there's no paid leave provision that would apply even up until December 31st.
So what if they were quit for whatever reasons? Maybe they were being told they had to travel, or they were just afraid of getting COVID coming into work. Once an employee quits, are they eligible for unemployment? Is that Tim?
This is Tim. As a general matter, an employee who voluntarily quits his or her job is not eligible for unemployment. And if what we're talking about is simply a generalized fear of getting COVID, that is what animates the employee to quit, I would not expect the Department of Labor to find that person eligible. However, if there's something uniquely or abnormally dangerous, or there was an unusually high risk of exposure created by the work assignment and the employee quit to avoid that, the result would be different.
Great. And if we need to have a policy in place, if we're requiring or encouraging employees to receive the COVID-19, I think you addressed that earlier in your comments, but if you could just, someone wants to field that question as well.
Right. So I'll take that. So should you have a policy in place if you're going to make it mandatory or voluntary to receive the COVID-19 vaccine? And the answer is yes. Employers should develop a policy to outline any requirement or recommendation for the COVID-19 vaccination in the workplace. And there are templates available for sample policies through SHRM, the Society for Human Resource Management. I saw a question come through with that before.
And Tim, earlier you had mentioned really just having a process in place to field questions and concerns from employees. How do you want to help employers address the questions that they may have about the safety of the vaccine? Is there any guidance you can provide there? Sorry,
I unmute there. What I would suggest doing there is referring employees to the latest guidance from the Centers for Disease Control, which has done a pretty amazing job during this pandemic of keeping their website up to date on subjects, including what I would expect to be forthcoming now is vaccine safety.
And our next question is, so can you ask employees to show proof that they have received a COVID-19 vaccination?
The answer is yes, you can. And some questions were initially raised about whether or not that would constitute a medical exam under the ADA. And the EEOC guidance anyway has said, no, it's not going to be considered a medical exam, which triggers some other obligations. So you are permitted to ask employees if they have received the vaccine under the recent EEOC guidance, which has been appropriately caveated is incomplete, but a good starting point.
And again, you addressed this in your presentation, but just to put a fine point on this, if you do adopt a mandatory vaccination policy, an employee refuses to comply, can you fire that employee for that refusal?
Not right away. Like I said, if you're going to fire an employee for anything related to vaccines and whether or not the employee is going to get it, I think that one of the first things you should do is get some legal advice from counsel or from a trusted advisor at Hickok and Boardman who can help you navigate that, because as I explained, it's not nearly as simple as the New York Times made it sound.
Yeah, for sure. It's going to, even as better guidance becomes available, the answer is going to depend on the reason that the employee is refusing, which could be because the person actually does have a bona fide medical condition that makes them unusually susceptible to adverse reactions from the vaccine, or it could be a religious objection, both of which will, I suspect, continue to be grounds that would permit an employee to refuse. At the other end of the spectrum, if it's somebody that just says, I prefer to be a free rider and avoid COVID by relying on everybody else getting the vaccine, that's where we anticipate that the guidance will be clear that that's not going to be an acceptable excuse to avoid an employer required vaccine requirement.
Okay, thank you. So with the CARES Act requirements, how does that interact with collective bargaining agreements across the state?
So that's a tricky one. I would say under the CARES Act, talks about, nothing in this statute should interfere, with individuals' rights under the collective bargaining agreements. That's a bit of a dodge, if you ask me. But again, collective bargaining agreements have their kind of own obligations, and there are provisions that could require notice and opportunity to respond and for certain things to be bargained. And one of the points relative to that that's important, I think, through this whole conversation is all of this stuff is tricky, right? And it's constantly shifting, and involving your employees to the extent that you can when you're developing these policies and in the decision-making process is something, frankly, we always advise our clients to do. Helping them to understand the why behind your decision-making process and being as transparent as you can as you're making these decisions along the way often goes a long way to preventing ending up in lawsuits and in legal situations. And that's true for the collective bargaining and the union process as well. Even if you're sort of on the fence as to whether or not a particular issue is bargainable or is simply just something for which you need to provide notice, but is not something that's bargainable, or not notice at all. Sometimes involving the union in those discussions about, hey, we're thinking about having a mandatory vaccine policy. Here's an outline of what we're thinking it might look like. We would like your input into this. It can go a long way into stemming the possibility of complaints.
So here's one that's probably come up numerous times across the state leading into Thanksgiving and now the holidays. So if an employee knows they're going to be leaving the state for travel, Must they tell their employer? And then can the employer ask everyone, hey, tell us who's leaving? Or must the employer ask? So who gets responsibility there in that communication?
I can answer that with a recommendation. I think because of the current state of the executive orders in Vermont, it's advisable for employers to have a policy that's written and provided to employees that does require employees to provide notice of out-of-state travel plans over the holidays, precisely because of some of the quarantine and leave/remote work issues that I was speaking about earlier. But really the answer to the question is it depends on what is the policy that you've enacted, and have you provided that policy to your employees to require it. There's nothing in the law that prohibits an employer from asking employees to reveal out-of-state travel plans in the context of a pandemic and with the current executive orders.
All right, so let's say we've got an employee who has tested positive. Can we tell the rest of their coworkers that employee has tested positive?
I'm surprised at how often this actually comes up, but the answer is no. You cannot, and that's confidential medical information. We have, a lot of Vermont employers are quite small. And obviously somebody all of a sudden isn't coming in to work, and it's fairly normal for other employees to start asking around and sometimes asking HR, is this person out because of COVID? That sort of thing. No, you cannot disclose that information. You obviously, if a possible exposure has occurred to individuals in your workplace, informing of that is appropriate, but not the medical information of the individuals involved.
Is it okay if the individual is given permission?
If the individual gives permission to tell the coworkers that they have COVID, then yes.
Okay, yeah. Great. And sort of an obvious question, but I think one that we could explore a little more deeply is, do we have to allow employees to work from home?
So no, there's no requirement that employees be allowed to work from home. However, it may be a viable option during this time to both reduce exposure and the potential spread of the virus in the workplace. And as an example, our firm transitioned to telecommuting in March and has remained in that status because our type of work translates well to the work from home or telecommuting arrangement, and hasn't disrupted any of our business functions. Now, not every business is in that situation. But even if you don't allow employees to telecommute, if an employee has a disability that puts them at risk for complications, they may request telecommuting as a reasonable accommodation to reduce their exposure during the pandemic.
If I could just add on to that, I agree with everything Karen said. There is, though, in Vermont, a rather unique statute that requires an employer to consider a flexible worker arrangement for an employee who has presented one, and not only consider but respond to it in writing. Doesn't, on its face, require an employer to grant any such arrangement. And as Karen said, there isn't any such requirement, but certainly it's clear that there is a requirement to consider them.
Thanks, Tim.
Great. So we are approaching 1:55. We still had some of our prepared questions from the panel, or for the panel rather. I would like to make sure we do address a couple of these chat questions. So I'm going to drop down to those, and if we can get through those quickly, we'll go back to our other questions. So first question from Jennifer Jacobs. Question about motivating employees. Can you speak to offering incentives to get vaccinated? For example, providing extra vacation days for employees who do.
I think I raised that topic, so I'll try to answer this one. Yes, it is possible to offer extra vacation days for employees who get vaccinated. And there are similar incentives for the flu shot and that employers use. And I would consider implementing similar ones for the COVID vaccine if that's something your business decides to do.
Okay, and then a follow-up question here. If an employer offers the vaccine voluntarily, but an employee refuses, is it considered retaliation to withhold healthcare insurance coverage benefits for any possible COVID-related specific healthcare services if the employer is self-funded?
There's no, not that I'm aware of, there's no legal answer. There's no case that's been decided on this because it's so new. But if an employer came to me and wanted to implement that type of plan, I would say you're running a high risk of being on the receiving end of a retaliation claim. So the answer is, yeah, that could be considered retaliatory.
Here's one that I've seen asked in many different formats, and this gets into the weeds of really understanding where you are, if you've been exposed, are you positive or not. So the question from Lori Furland is, do we need to pay an employee to stay home if their partner or child are waiting for results from a COVID test? And if we ask them to stay home as a result of waiting for those results?
Well, after December 31st, it appears pretty clear that the answer will be no. You don't have to. Should you? Anyway, perhaps so. That's obviously sort of a business judgment call.
Any other panelists?
I'll just tag on that, not specific to that question, but to Tim's point about the should you. I mean, I think that a lot of these questions that can seem like you dive into the technical legal details, but just what's if your organization is able to, what's in the best interest of the employee and for the organization as a whole. And if you are going to be strict adherence to the letter of the law, and that means not paying or not putting the employee in a situation where they can afford to stay with you as an employer, are you really in the position to hire someone to replace that person? What does the labor market look like? And so trying to decide, some of those, cost benefit analysis when trying to decide if it's something that you could do.
Okay, and here's a question that I've had conversations with several nonprofits about, which I would interpret as just needing clarification around what the federal tax credit is. So this is a couple-part question from Cynthia Moore. Is an employer required to give additional paid time off if the employee has some available? And can an employer ask an employee to use their accrued leave prior to giving the additional leave? And lastly, how does a nonprofit get reimbursed given that they are not paying the federal payroll tax? So maybe we can break this up. I don't know if anyone wants to take any portion of that.
Would you mind reading the first question again, Adam?
Absolutely. Is an employer required to give additional paid time off if the employee has some available?
That may be the case depending on the situation. For example, Vermont's parental and family leave law, which of course entitles employees to up to 12 weeks in a year of leave if they have a serious medical condition. Unlike the federal statute, the state statute provides that an employee must be allowed to use up to 6 weeks of any accrued paid time off that the employee has to cover that time away from work. So if the employee has accrued sick time or accrued vacation time, gets sick with COVID and needs to be out and says, I want to use my 4 weeks of my accrued time, a Vermont employer must let the person do that. If they get to 6 weeks and they need to be out longer than 6 weeks, at that point, the employer can stop allowing them to apply their accrued leave to it. It's the requirement ends at 6 weeks, but in the first instance, the answer is going to be probably yes for Vermont employers.
Great. Would anyone like to take the question regarding the tax credit in federal payroll tax for nonprofits?
I'd be happy to look at it and follow up with the person. Candidly, that's what I would need to do in order to answer it.
And I would second that, although my understanding is that there, and this is a very preliminary understanding, I don't know all the details, but there is some way for nonprofit employers to obtain the tax credit or some equivalent. But I agree, I would have to look that up to know for sure.
Okay, well, we've captured that, and we will be sure to follow up with you and get that out to the folks who participated here today. So we are just after 2 o'clock. For my team here, are those the only chat questions that we've collected?
So far, Adam, I think that's almost all of them.
Okay, great. Any closing thoughts, comments from our panelists?
If I could make a quick plug here, Adam, for those who maybe have more questions or didn't get a chance to ask theirs. I know we only had a limited time here, but David and I and our practice group are launching what we're referring to as the DRM HR Cafe. This is for HR professionals. It's going to be a virtual platform for learning and discussion and exploration about HR issues. It's going to kick off on January 6th at 8:30 for an hour. And our first topic, we're going to pick a different topic for each session. The very first one is going to be strategies for slaying COVID burnout by our colleague April Tuck. If anyone is interested in being invited to participate and register for that, you could send David or me an email and we'll get you the information that you need.
Great. Karen, Maribeth, David?
Thank you very much for hosting this.
Yeah, thanks for hosting it, and thanks everyone for taking the time to participate.
Thank you, everybody.
Okay, well, on behalf of the RevTA team, thank you for joining us today. Gabriel, thank you for leading us off, and for the rest of the team at the BDCC behind the scenes. Much appreciated. Everyone have a great week. Happy holidays.
Great. Thank you.
Take care, everyone.
Bye.